Madam Clerk, anything we need to take up before we get started?
During the second case, Your Honor, the appellee would like to introduce a new attorney.
We will take care of that when we call that case then.
Yes, sir.
All right.
Thank you, sir.
You may call the next case then.
Thank you. Marvin L. Miller versus City of LaFollette et al.
We're ready.
Thank you. May it please the court, Ms. Reed, my name is Scott Miller and I represent the appellant in this matter, and we are asking this court to remand this case back to the Chancery Court with instructions to issue a determination that attorneys' fees and costs are appropriate in this case due to the willfulness violations based upon the Tennessee Public Records Act. At this time, I would like to reserve an additional 2 minutes for rebuttal. 2 minutes?
All right,
Yes.
sir. You may proceed.
This case starts with the Tennessee Public Records Act, Your Honors, and under the Tennessee Code annotated, it says public records shall be construed broadly so as to give the fullest possible access to public records. Not only that, the courts have been directed to interpret the act broadly to give the fullest possible access. And there's a clear mandate in favor of disclosure, a presumption, so to speak, that says records that are created on behalf of the agency should be subject to public inspection. And in this case, there are 4 glaring issues at stake that show the City of LaFollette violated the Tennessee Public Records Act. The first one is the most obvious, the failure to respond initially prior to the Chancery Court petition being filed. And these glaring deficiencies were pointed out during the prior to the hearing, where we gave notice that they were deficient, yet still received no response from them. The second was the failure for them to provide any reason for the denial of these additional documents. And then the day of the petition, that the first hearing on the show cause hearing, they produced an additional 200 documents on the first day. An additional 800 documents over the next 3 months related to our original request. They also, after the petition had been filed, gave a reason. They said, first off, we think we've produced everything. However, if they exist, they're protected under the work product privilege, which the work product privilege relates to this investigation that was conducted by an attorney for the City of LaFollette. And work product is documents that are created in anticipation of litigation. This wasn't someone acting as an attorney, but as an investigator. And furthermore, that investigation was provided to the City of LaFollette for their use in determination of discipline. So, and what you've read within the briefs is the fact that they destroyed a portion of those documents that they later claimed were created in anticipation of litigation. So,
Are those the specific documents you're talking about?
excuse me, Your Honor?
Are those the specific documents that you're talking about here?
Those are just a small portion of the documents we're talking about. One of the documents relative to that was not disclosed was the email between the city administrator and Celeste Herbert authorizing the destruction of those documents related to the investigation that was conducted. The additional documents that were provided, almost 1,000 of them, after the Chancery Court petition had been filed, are also the documents we're referencing. The initial violation, failure to give any reason for withholding those documents, and then the later destruction, and after the petition being filed, the notification that if they existed, they're being held pursuant to work product.
Does the fact that the court said that those additional documents were not particularly relevant, is there any consequence to that?
Your Honor, I don't think the Chancery Court said that. The Chancery Court specifically said that that the City of LaFollette failed to meet their obligations by not doing an adequate search to begin with. And if you look at the testimony...
Well, I think what he said was on the second and third days of hearing, additional information was provided, most of which was not particularly relevant.
Your Honor, there was over 1,000 documents we received after we filed the petition. 1,000 documents, and it was a complete document dump. And there were many of those documents that we were like, why are they providing all these documents at this time? But if you look at the record, there are specific documents that are referenced that are directly related to our request. And Stan Faust even conceded that under testimony, under oath, where he was asked, did you have this document in your possession prior to the initiation of the petition? Yes. Did you turn them over? No. Do you think those should have been turned over? Yes. On at least 5 different occasions, that was the testimony, either as it relates to him or as it relates to Sergeant Duff, who had 2 separate records that were directly related to the investigation that were not disclosed prior to the petition being filed.
I mean, the court also made a finding that the attorney who did the investigation, and I think Mr. Faust were not on notice with regard to these investigative records, whether they were work product or not, but they were not on notice prior to the time that they were destroyed. Your
Honor, the destroyed documents were on August the 3rd. We submitted a request on August the 3rd. Let me say that another way. Stan Faust authorized the destruction of those documents on August 3rd via email. That email was withheld, first off. We sent a records request on August the 5th, and we sent a preservation letter on August the 5th. What is specifically concerning to me in this case is that he made no efforts after that preservation letter was sent to call Celeste Herbert and say, hey, we've got this preservation letter, hold on to those records, I just told you to destroy. And furthermore, I think he is required, under his testimony, there was a 1-year statute limit, or 1-year retention policy that required him to maintain those documents for at least a year. And he says in his testimony that he destroyed them within 1 day of the investigation summary being submitted to the city of LaFollette.
Well, the court made a finding that said, according to the proof, the records request and spoliation letter was not received by the city until August the 8th, 1972. 2020.
And that was based upon the testimony of Stan Faust, who says he did not receive it till the 8th, but the fax receipt, the email read receipt indicates it was received on the 5th.
This is the court's finding. I
understand, but even if it's the 8th, he still made no effort to try to remedy that destruction of those documents.
Well, you have to assume that the attorney was an employee of the city.
Excuse me?
Are you assuming that the attorney was an employee of the city?
I am assuming that the attorney was an agent of the employee and was contracted to do a specific task for the agency that the agency would otherwise be required to do under law. An investigation that was brought about from a complaint filed by an employee on to other employees to determine discipline with that particular employees that the complaint referenced. So this relationship was an agency relationship where this was a small one-time task that they contracted with to conduct this investigation. And therefore she was an agent of the city of LaFollette, not an employee, but an agent.
Let me ask you, were you able to determine whether or not the records that you requested were destroyed after the 8th, when the city said it had notice of the public records request?
That was one of our concerns with the findings of the Chancery Court. The Chancery Court found that, but the testimony in the record does not support that. The testimony in the record was from Celeste Herbert. She was not sure when she destroyed the records, which included interview statements, which included recordings of witnesses that had critical information to the basis of the findings or the summary of the investigation. So we were not... Could you not have conducted your own
investigation with these witnesses? I'm not sure why this investigative material that you obtained a copy of the report, but I'm having a hard time. It sort of reminds me of discovery information where you're trying to discover attorneys' thinking with regard to expert witnesses and whatnot, or their investigation of an incident, where you're not entitled to that unless it's not available to you in any other way. couldn't you have done your own investigation, taken your own depositions, done whatever you wanted to do with these witnesses? Why are you entitled to her investigative file?
That investigative file was relied upon to terminate my client from employment. And the investigation...
The report was what was relied upon, wasn't it?
The report summarized her conclusions, which did not identify one witness, did not give a summary of what one witness said or who all was interviewed, didn't provide any basis for how she formed those conclusions, which is the very nature of what you're trying to determine under the Public Records Act. That information should have been readily available to my client, who, by the City of LaFollette's own policy, was entitled to notice and hearing before being terminated, both of which he was not allowed to have. He was also entitled to a name-clearing hearing under the U.S. Constitution, which we requested, which we got also no response to, including the deficient response to our public records request.
That has nothing to do with what we're talking about today, does it? Neither of those things have anything to do with this.
Your Honor, it has to do with the fact that shows the willful intent to undermine the Tennessee Public Records Act by having these documents destroyed, intentionally not providing us. What we ended up getting in the document dump as well was the names of the witnesses that were interviewed, the scheduling criteria for the interviews, the coordination of it, and glaringly missing that we received after we initiated the petition was the email authorizing the destruction that was located in Stan Faust's deleted items folder by IT, and a follow-up complaint from a sergeant to Celeste Herbert on specifically related to the actions of my client. We were not given that information as well. And this is all information that should be readily available, especially not only to the public, but especially to someone who's fighting for their job and looking for how they're going to best defend that job. So based upon the totality of the circumstances, when you look at this case, he was required to retain those records. He failed to retain them, and then he failed to attempt to preserve those. This is all evidence of a willful violation under the Tennessee Public Records Act, including the fact that they violated the Tennessee Public Records Act initially by not giving a sufficient response, which the Chancery Court concluded after the first day, hold on, you all have to go back and do this over. You did not sufficiently provide the documents that were requested, or you didn't sufficiently conduct a search as was required. And they went back, did the IT, and did the IT search, and that's when we get the document dump with tons of documents that weren't relevant, but many of them were directly on point and directly relevant to our initial request.
What did the trial court find about the failure of the city to maintain the records according to its policy?
She found that it was concerning that he would not have retained those records. However, felt like and concluded that the records had been destroyed prior to our request. And I disagreed with that because the testimony in there shows that it's questionable whether they had been destroyed at that point, and an effort could have at least been made to try to do that. He doesn't even have...
Bear with me a minute. You're telling me that there's a policy or a rule that the city has to maintain those records for a year. Is that correct?
That's Stan Faust's testimony in the second day of the hearing, Your Honor.
Okay. And these records weren't. Was there an explanation as to why these particular records were not maintained?
Prior to the petition being filed, no explanation whatsoever.
Was there ever an explanation?
During the 3-day hearing, there was an explanation that they gave that said, well, these weren't city records. These were her records. We don't have anything to do with that. I see I'm out of time.
Okay, so and you can answer my question. The distinction was the court found these weren't city records then. Is that correct?
That's correct, Your Honor.
Because of the status of the attorney doing the investigation.
And they applied the functional equivalency test, which was not the proper vehicle for determining whether or not these were agency records. The agency test is the simple test that should have been applied, that these documents, and remember, under the statute, documents are defined as documents created by the city, on behalf of the city. And that's what these documents were. They were created on behalf of the city, and the court found that those records had been destroyed prior to our request.
Okay.
Let me ask you one other thing.
Yes,
In
Your Honor.
connection with the 800 documents that were provided after you filed the lawsuit, in connection with your request for public records, which request were they responsive to? Because I think you made 4 or 5 requests. Can you tell me which one it was responsive to? Because I know you complain about not being provided the personnel file for Mr. Miller, but as I look at the request that you made, you didn't specifically request that.
The personnel file?
Yeah.
That was the 200 documents that were initially presented. Our request related to any investigative material on Monty Miller within the last 6 months, I think is how it's worded. And that would include, within his personnel file, included the complaint from Duff, which is relevant to that, the investigation from Celeste Herbert, which was also relevant to that, within the personnel file itself. And the other 800 documents also included documents, like I said, that were directly relevant. There was a draft complaint of the complaint that Sergeant Duff filed between him and Captain Wallen, where there was changes made and edits made. That Stan Faust also conceded that that should have been turned over. The investigation into Monty's conduct that Mr. Duff submitted to Celeste Herbert, he conceded that that was documents that should have been turned over. He conceded that some of the documents he had in his possession prior to the hearing should have been turned over during the second day of testimony.
Thank you. You've got your rebuttal time.
Thank you, Your Honor.
Yes, sir. Hear from the appellee.
Good afternoon, Your Honors. My name is Courtney Epps-Reed, Knoxville Bar. I represent the City of LaFollette and Stan Faust. Going back to some of the questions posed by the court, let's talk about what was produced and when it was produced. What's really at issue here in the response to Judge Armstrong's question is the any investigative material related to Marvin L. Miller in the last 6 months. Initially, Stan Faust, who is the City Public Records Request Coordinator, provided the Sergeant Duff grievance, the report of Celeste Herbert, the outside attorney investigator. He tried to upload the personnel file of Mr. Miller to Counsel Miller's paralegal, which didn't work, which is why at the hearing that was produced, the 200 pages at the first hearing. And he also produced the city's personnel policies and the LaFollette PD general orders. At the time, the city did not understand the scope of what Mr. Miller was requesting. And what's key is that the records that were destroyed, Your Honors, was Celeste Herbert's own notes and recordings that were never in possession of the city. So the trial court found those weren't public records of the city. The only thing the city was provided was the Celeste Herbert report of her investigation, which, as Your Honor Golden pointed out, was what City Council relied on. And in the appellant's brief, they say that the city waived the work product privilege of Celeste Herbert's notes and recordings, but they didn't, because City Council and the city has never, ever seen those notes or recordings. Again,
Does that make a difference?
I think it does, Your Honor. I think it goes back to what the appellant wants the court to hold, is that any time a private attorney performs a task for a city, all of their records automatically become public record. I don't think that's what the courts have said.
But let me pose a different question to you then. Did the city have a right to see Attorney Herbert's records?
They didn't ask for them, but she testified, Your Honor, that she and the city attorney, Reed Troutman, after receiving the second letter from Mr. Miller, that they had a conversation with her. Mr. Faust testified in the record that he was told those were her work product. Celeste Herbert testified she didn't recall that conversation, But she did testify under oath that if they had asked me for those notes, I wouldn't have given them to them because they're my work product.
Would not have given it to the city?
Yes, Your Honor. That's what she said.
It's interesting.
Also, as
Is that her privilege to assert?
I'm sorry, Your Honor.
Is that her privilege to assert?
I do think so, Your Honor. She's an attorney. It could be her work product.
If that's the case, why did she call the city and ask them if it's okay if I destroy my records?
She sent him an email on August 3rd and said that was her usual practice, and Mr. Faust authorized it that day. Again, as pointed out earlier, the city did not receive the preservation request or
Does the city have to? I mean, most times in a lawsuit, when you're kind of on notice of what the cases say about destroying evidence or purported evidence. You got a car wreck and you destroy the vehicle that was involved in the accident, then it becomes problematic. Spoliation of evidence. I know that's not what we're talking about here, but obviously this was a hotly contested issue for the city and the individual. So it's very troubling to me that all this occurs and then we get a request from the investigator and the city says, yes, destroy those. And they're gone, although everybody seems to recognize that the controversy had not ended.
at the time, so just for a little bit of a timeline, again, August 2nd is the date of Celeste Herbert's report. On the afternoon of August 2nd, her report was provided to Stan Faust, who dispersed them to city council members. On August 2nd, the city council meeting was held, which terminated the employment of Mr. Miller. I don't know, I can't answer, Your Honor, there's no testimony in the record as to why that's Celeste Herbert's practice is to shred her documents. What I can state is that Mr. Faust testified that he had no notice of any there was going to be a request from Mr. Miller relating to any public records of the city. Mr. Faust consulted with the city attorney at the time of the receipt.
That's really sort of I understand there may not be any testimony in the record, but you've got an ongoing controversy. You've got litigation essentially going on.
There was no lawsuit filed at that point.
There wasn't a lawsuit filed by Mr. Miller at that point relating to his employment, Your Honor. That wasn't filed till much later.
Let me ask you, this investigation by Ms. Herbert, was that in anticipation that there was going to be a lawsuit filed?
Your Honor, I think it was because it was a complaint of harassment by a city employee, and because the city was aware of ongoing issues and controversy in the city police department, city council thought it best that it be handled by somebody outside the city to investigate the harassment. But I think, Your Honors, as cited in my brief, it could still be work product even if a specific case has not been filed. It could serve the dual purpose in the Tennessean versus Tennessee Department of Personnel case to be following a policy to investigate complaints of harassment, but also to be work product of that attorney.
Does it make any difference that here you've got a government entity that is the client as opposed to a private entity as far as the work product is concerned? Because the Public Records Act doesn't apply to anybody who's private, but government is a different situation.
Yeah, Your Honor, you're correct. And I think the case law is very clear. Arnold versus City of Chattanooga reported in 1999. Court of Appeals case, Swift versus Campbell reported, Court of Appeals case from 2004 says the work product doctrine can apply to governmental entities and can be an exception to the Public Records Act. And it's why I think this analysis of whether Ms. Herbert's records, including her notes and recordings, automatically become public records of the city. And I do think the functional equivalent test as set forth by the Supreme Court in 2002 in Memphis Publishing Company applies. Mr. Miller's counsel has said he relies on an opinion that predates that in 1990. But even in the Creative Restaurants opinion, it talks about that you have to decide on a case-by-case basis based on the specific facts as to whether documents in the hand of a private individual automatically are subject to the Public Records Act. So I think it's a case-by-case analysis, and I think the trial court got it correct in this instance. This is the only investigation that Celeste Herbert has performed for the city of LaFollette, and under that test is set forth in the Cherokee Children and Family Services opinion. She
Let me ask you a question.
Sure.
that I posed to opposing counsel, and that is, he asserts that there is a requirement that the city maintain these documents for at least a year. Do you agree with that?
Mr. Faust's testimony was that there was a year retention policy. He, I think, was confused by the question because there's not a written policy. You can look in the city policies and that are in the record. They don't have a records retention policy. What he was referring to was that they have to, under the Public Records Act, retain public records requests for a year. In any event, I think it goes back to what were the records that weren't preserved. It wasn't anything the city had in its possession. It goes back to...
Let's answer the general question first. Is there a policy by the city that they retain these documents for a year?
No.
Okay.
He testified that there was a one-year policy incorrectly because I think he misunderstood the question. As an attorney for the city, no, there's not a one-year retention policy. His testimony when asked that question by Mr. Miller was yes. But what he was referring to was that in the Public Records Act, they have to retain public records requests themselves for a year. But I think that's, Your Honor, respectfully, I think that where that comes into play, the records retention policy, is again going back to Celeste Herbert's notes and recordings, which they never had, and she testified she wouldn't have given them to them. So that's what they didn't retain. And as far as the other documents that were produced after the city received clarification as to what was specifically asked, a lot of those were, they thought it just had to mention Mr. Miller specifically, and what they ended up producing was all emails between Celeste Herbert and any city employee or official, and primarily those emails were just scheduling the interviews and figuring out who to interview. There were only 4 emails that were additionally produced that actually mentioned Mr. Miller. There was 2 different emails from Sergeant Duff's personal email address, which was not from the IT search, and that just simply attached 2 different versions of his grievance that were emailed to a city employee. There was an email from Stan Faust to City Attorney Troutman, which was just forwarding Ms. Herbert's August 2nd report. And then third, there was an email from Mr. Duff's personal email address. Again, that was outside of the IT search, to Celeste Herbert that did mention Mr. Miller, and that email should have been turned over originally, but he misunderstood what Mr. Faust was wanting when he first asked him about the public records request. And all of these records, once the breadth of what was being understood by the city, were turned over prior to the October 17th, 2022 hearing. Even counsel for Mr. Miller said in the first hearing, at first, he didn't think what the city was doing was willful. They didn't understand what was being requested. The other documents that were turned over that took up a lot of these pages were personnel files of Captain Wallen, Sergeant Duff, and Brian Tiller, all of which have nothing to do with the initial request and Mr. Miller. As you can imagine, personnel files of police officers can be thick. There was also a tracking log related to Brian Tiller that has nothing to do with Mr. Miller. There were findings of a TBI investigation provided to Celeste Herbert that just related to another employee, Captain Wallen, that had nothing to do with Mr. Miller, and also a list of all the city police department and dispatch employees that were provided to Celeste Herbert. Because at the time of that hearing, once the city understood what was being requested, they turned over anything and everything that they gave to Celeste Herbert, that was city record, and any and all emails they had with her. So really, it goes back to this, the whole issue here is whether the city willfully refused to disclose records. And mere negligence on the part of the city for not involving an outside IT agency to begin with does not equate to the willfulness standard. And again, this isn't a situation where the city was relying on an invalid legal justification. When counsel for Mr. Miller reached back out on August 11th, Stan Faust testified. He got in touch with the city attorney, and they then had a conversation with Ms. Herbert if there was anything else. And then the city attorney responded to Mr. Miller, and that's when he said they don't have any other material of Celeste, which is true with the way that they were interpreting it, because the only thing she gave them was her report. And I think the trial court was correct in holding that the city did not willfully violate the Public Records Act. I think the trial court was correct that Ms. Herbert's notes and recordings were not public records of the city, and thus they did not willfully destroy public records based on that email of August 3rd. And I would ask this court to affirm the holding of the trial court.
Thank you. I believe you have 1 minute, counsel.
Did you say 2 minutes or 1 minute?
All right. What'd you ask for?
5 minutes? No, I'm just kidding. 2 minutes.
Yeah, they're running together on me today. I'm sorry. Go ahead.
Thank you, Your Honor. There's a lot of misunderstanding here, and I think if you, on this part of the city of LaFollette, and if you go back to the presumption that these records are subject to disclosure to the public, that's your starting point. There will be no misunderstanding. You will make a conscious effort to make sure you're following the law and you're doing what you're supposed to do immediately. As it relates to the TBI investigation, if you go back and look at Sergeant Duff's complaint, his complaint was on Mr. Miller falsely accusing this other employee of a ticket fixing scheme that the TBI investigated. That's specifically within the complaint from Duff. So how is that not relevant to our inquiry? Search terms included investigation, Miller, discipline. Those are all things that would have easily been found with a basic search. Certainly Stan Faust would have been able to locate the email with Celeste Herbert that he had just destroyed or entered into his deleted items folder 3 days prior. So all these misunderstandings come back to they can easily be avoided. We don't want the agency or the city of LaFollette having some uncertain response of how they're supposed to handle public records requests, and that's just not the case here. Even if you look at the initial portion of it, as she mentioned, the work product privilege was not put forth until after the petition was filed, which under the case law is it meets the willfulness standards to provide that after the hearing, and it also meets the willfulness standard when you fail to give a specific work product privilege. You can't just give a blanket privilege. Well, those are privileged under the work product doctrine. That's not how the privilege works. There has to be an examination of the documents yourself in order to claim that privilege. So you focus on the anticipation of litigation here, and yet the focus was on the anticipation of litigation, but they destroyed those documents. That makes no sense to me. I see I'm out of time, Your Honor. I appreciate the opportunity, and I would, yes, sir.
Let me ask you, apparently, at some point, a number of documents are provided. A lot of them went to scheduling interviews and all by Ms. Herbert. Do you say that those records were included somehow in the 5 requests that you made?
Yes, Your Honor. Those
Under
relate
which one?
related to the investigation into Mr. Miller. These interviews were being scheduled to determine facts and circumstances under which to discipline him and then ultimately terminate him. That's not a hard interpretation to reach when you say related to the investigation into Mr. Miller. Key words: investigation, Miller, discipline. That's a guideline for them. That's not what they have to go by necessarily. They should have done a thorough they should have known those documents were readily available to the public. Those are easy emails related to our request, direct request related to the Miller investigation. And that's how we had no idea who the witnesses were. We had no idea who was interviewed. They were recorded statements of every one of these witnesses that are gone, that you are claiming are under a privilege but are now don't exist for you to use in anticipation of litigation that is now pending. So I would ask this court to remand this case back to the Chancery Court for determination of reasonable costs and attorney's fees associated with the petition as well as the appeal for the City of LaFollette's willful violation of the Tennessee Public Records Act prior to the filing of the petition with the Chancery Court and for their conduct after the petition was filed.
Let me ask you, do you take issue with the holding in the Arnold case that counsel mentioned that seems to provide that if a agency fails to disclose documents but doesn't do it in bad faith, that in those circumstances, a trial court could then not award attorney fees, even though there were records that perhaps should have been turned over?
I didn't hear which case
But not willfully withheld. Arnold versus the City of Chattanooga.
Your Honor, the bad faith element was created in Schneider versus the City of Jackson, the Tennessee Supreme Court case. And it simply states that it's a adherence to the law. How clear is the law at the time? Well, initially the law is clear. You have to respond to the request. You have to deny the request. You have to give a reason for the denial if you deny it. That is as clear as the Tennessee Public Records Act can be. And they did none of those things until after the petition was filed. They could have said, also by statute, hey, can we have some time to get these documents together and look through our files and try to find them? That's allowed for under the statute. They just simply ignored us. They ignored our August 11th deficiency letter and a reminder in that letter that said you have 7 working days in which to respond to this. They ignored it until after the petition was filed. That in itself is a violation that meets the willfulness standard under existing case law. So, thank you. I would ask that you remand this case back for further proceedings to determine reasonable costs and attorney's fees. Thank you.
Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time.